Hi everyone. Today I will tell you how a legal contract is properly formed.
Hi, I'm Dafan the ProfessorZ, your real-life homeless to Ivy League professor, attorney, and serial entrepreneur.
In the previous video, I explained that contracts are just enforceable agreements between two or more parties. So how do those agreements get formed? And what's necessary to form a valid agreement that's enforceable? The answer is surprisingly simple. It just comes down to these four things. The first thing you need is an offer. Remember, the agreement is exchange of two promises. That means one party is offering one promise in exchange for the other party for their promise in return. So in order to properly form an agreement or contract, first thing you have to have is an offer. So party one must first make an offer to perform a promise in exchange for a promise in return. Using the same example as before, I promise you $5 if you promise to take my dog out. That's an offer for an agreement to be made. I agree that if you fulfill your promise of taking the dog out, I will fulfill my promise of paying you $5. Once this offer is made to you, it's open until you accept it, which leads to the second element, acceptance. Generally, once the offer is made, it stays good until the offer is accepted or rejected, or sometimes retracted. Once you've been given an offer, naturally, you can just choose to accept it. You can communicate this acceptance. You can say, I accept your offer. I promise I will take your dog out in exchange for the $5 you promised me. Or on the other hand, if I really don't want to do it, I can deny it. I can say, I reject your offer. Or I can just say no. But frequently, something else could happen as well. I could make you a counter offer. I could say, I wouldn't mind taking your dog out, but I'd rather have $10. So I will take your dog out if you give me $10. That's a counter offer. That means I rejected your first offer and I made a different offer based on the first offer and offered it to you. So then you, party one, the person who made the original offer, can now have the choice to either accept it, reject it, or make a further counteroffer. This can go back and forth until one party accepts the previous offer from the other party, whether it be an original offer or a counteroffer. If neither party wants to accept any of the offers, the talks break down and we have no agreement. And sometimes a party changes their mind and they retract their offer. If that happens, once it's communicated to you, you can no longer accept the offer. The third necessary element to a contract is consideration. You think you know what the word consideration means? Think again. Lawyers like to make it difficult. Consideration, although a very common word, has a special meaning in contract law. In most instances, think consideration as compensation. Consideration means a thing of value being exchanged. If an agreement does not have consideration attached, meaning there are no things of value being exchanged in this agreement, then it cannot be a valid enforceable contract. This goes back to the first lessons we had about contract. Remember I said a promise is just a promise and there is no consequences attached to it. The consideration is the idea that something valuable must be attached to the exchange of promises in a way as consequence and leverage. Another way to look at it, nothing comes for free. And for a contract to exist, both sides has to get something valuable. Now I said in most instances, this is compensation, but it doesn't have to be. Consideration can be an act, can be an action, can be something that you do for the benefit of another. So promising to do something is consideration for a contract. But no contract can be validly formed without one side giving up something in return. One of the most common ways to attack a contract is to see if there is sufficient and adequate consideration. So make sure when you reach an agreement, both sides are getting something. Lastly, in order for a valid enforceable contract to exist, both sides has to agree to the same thing. This is called meeting of the mind. If you go to law school, one of the most famous stories that you will hear in contract law is about a ship named Peerless. The case goes that two parties contracted a ship, and the ship's name is Peerless. However, for some odd reason, there were two ships named Peerless at the time. And one party thought they contracted one of the ships, and the other party thought they contracted the other ship. So in essence, they didn't really agree on the same thing, even though they both thought that they did. In actuality, they were agreeing to two different things. Party A hired ship 1, and Party B hired ship 2. There can be no valid contract in that scenario because the parties didn't agree to the same thing. In practice, contract law is much more complex than that. This is a basic understanding of the elementary requirements to a valid and enforceable contract. If you have a contract that you have question about, please make sure that you consult a business lawyer. There are a lot of nuances to contract law in any particular contract. Only a lawyer can help you fully understand what's involved. Until next time, this is Dafan the ProfessorZ, guiding you on your journey to success, freedom, and satisfaction. Be successful.